All right, so have you ever thought about what you'd do if you actually saw a crime happening?
Oh, yeah.
Or like, even worse, if you were the victim? I mean, what would be the very first thing you'd have to do to, to get the legal process even started?
Yeah, to get the wheels of justice turning.
Exactly. It's a pretty fundamental question, right? And the answer to that question, actually, it's changed a lot recently with some pretty big changes in how our legal system works.
Yeah, big time. And that's exactly what we're going to be diving into today.
So this is what, the fourth episode now of Legal Snippet Law Simplified?
That's right, yeah. We're kind of making this a regular thing.
Yeah, and today we're going to be continuing to unpack this huge transition from the old Code of Criminal Procedure from 1973, the CRPC, to its successor, the Bharatiya Nagarika Suraksha Sanhita 2023,
Right, the BNSS.
the BNSS. And this one is a big one because at the core of this whole legal transformation is something that everyone's probably heard of but probably doesn't fully understand, and that's the FIR.
Oh, yeah.
The First Information Report.
Super important.
So today we're going to be really digging deep into what it actually means in this new legal landscape under the BNSS
Yeah.
and why it's still considered such a cornerstone of the entire criminal justice system.
Absolutely. It's the foundation. So
See?
FIR, when you really break it down, it's that very first official record of a cognizable offense, one of those more serious crimes where the police can actually arrest someone without needing to get a warrant first.
Right.
And you lodge it with the police. And that's what really kicks everything off, sets the whole criminal justice process in motion. Without that FIR being registered, no investigation, at least officially, can really begin.
Right.
And there have been so many landmark cases that have really underscored, the importance of the FIR as that essential first step. Like one that comes to mind is Lalita Kumari v. Gavetrate of UP back in 2013, really hammered home, the importance of it as that starting point.
So it's not just some bureaucratic formality or paperwork. It's like the official acknowledgement, right? That something serious enough to actually require the police to get involved has been reported.
Exactly.
And to really understand how all of this is changing, we need to take a look at a really crucial recent legal decision.
Oh, absolutely.
And not just any decision. This one came from the highest court in the land.
That's right. The big one, the Supreme Court.
So we're going to be focusing today on Imran Pratap Ghati v. State of Gujarat from 2025.
Yes, pivotal case.
This ruling, it does a lot. It provides some much-needed clarity on the actual procedures for registering an FIR under the BNSS.
Yeah.
And it's especially insightful when we compare it to how things were done under the old CRPC.
Oh, for sure. Lots of changes to unpack there.
So for all of our listeners out there who really want to grasp this really, really fundamental aspect of the law, what's the game plan for this deep dive into FIRs under the BNSS?
Sure.
Especially, with this Imran Pratap Ghati case as our guide.
Okay, well, first, I think we should lay out step by step how an FIR is registered now under the BNSS.
Sounds good.
Then we'll get into one of the biggest and I think most interesting changes between the CRPC and the BNSS, and that's this thing called a preliminary inquiry.
Oh, okay.
And then we'll tie all of that back to the specifics and the implications of the Imran Pratap Ghati case that you mentioned from the Supreme Court.
All right, so let's dive right into the practical stuff then.
Okay.
If someone out there needs to report, let's say, a serious crime under the Bharatiya Nagarika Suraksha Sanhita, what are the first steps that they need to take to get that FIR officially registered?
Okay, so that's all laid out in Section 173 of the BNSS. Basically, it says if you've got information about a cognizable offense, you've got the right to give that information to the officer in charge of the police station.
Okay.
And what's interesting is that you can actually do this a couple of different ways.
Okay.
You can go in person and do it orally at the station. Or, and this is becoming more and more common these days, you can actually do it electronically. Oh, okay.
Through email, or sometimes police departments have these online portals specifically for this kind of thing.
That's a pretty big modernization. Makes it a lot easier for people to report. So once someone gives that information, what happens next? Like, does it depend on whether they report it in person or online?
It does, a little bit. So if you give the information orally, the officer, they're required by law to write it all down. Then that written record, they have to read it back to you, the person who reported it, to make sure it's all accurate. And once you're satisfied that it's correct, you're going to need to sign the document.
Right. Makes sense. Got to make sure there's a clear record from the beginning and that it's verified.
Exactly.
So what about the electronic reporting option?
If you go that route and submit your report electronically, the officer still has to take it on record officially. But to make sure there's still a formal signed record, you as the informant will usually need to physically sign a copy of that information within 3 days of submitting it electronically. Oh, okay, so it kind of bridges the gap between the convenience of digital reporting and still having that, that signed official document that's needed for any kind of legal proceedings.
Yeah, exactly. Best of both worlds.
Now, after all that, does the person who reported the crime, do they get any kind of confirmation, an official acknowledgement that their report has actually been registered?
Oh, absolutely. The BNSS is super clear about that. It's all about transparency.
Right.
So Section 123(2) very clearly says that a copy of that recorded information has to be given to you, the informant, or the victim. And it has to be given promptly and free of charge.
Okay.
So you know they're not going to make you pay for it or anything. This is so important because it makes sure that you have official proof that you reported it and you have a record of exactly what was documented.
Perfect. Okay, so the process seems pretty straightforward, but let's get to a really important question now.
Huh.
Under the BNSS, are the police required to register an FIR every single time they get information about a cognizable offense?
Mm-hmm.
Is it always a mandatory step?
Yeah, that's the thing. The general principle is still that registering an FIR is absolutely mandatory if the information given to the police actually shows that a cognizable offense has been committed.
Okay.
Section 133(1) of the BNSS is pretty much the same as Section 154 of the old CRPC in that way. And in fact, in that Imran Pratap Gadi case, the Supreme Court really doubled down on that fundamental rule, stating that no further inquiry can be made by the police officer if the information discloses the commission of a cognizable offense.
Okay.
And this is all building on what we've learned from cases like Lalita Kumari.
Okay.
It just emphasizes just how important that FIR registration is in these scenarios.
So if the information points to a serious crime, the police, they have to register the FIR. No questions asked.
Well, not so fast.
Okay.
This is where things get really interesting with the BNSS. There's a pretty big new development that we need to talk about.
Okay.
And it has to do with something called a preliminary inquiry.
Okay.
It actually offers a slightly different approach for certain situations.
All right, a preliminary inquiry. What exactly is that, and when does it come into play with this new law?
So a preliminary inquiry, it's basically this initial assessment, like a fact-finding exercise. And the police, now they're actually allowed to do this before they decide whether to formally register that FIR.
Oh, okay.
But this doesn't apply to all cognizable offenses. It's specifically limited to certain types.
Right.
So Section 173 of the BNSS says this only applies to cognizable offenses where the punishment could be imprisonment for 3 years or more, but less than 7 years.
Okay, so it's kind of like specific category.
Exactly, a specific category. It's like this middle ground of offenses.
Right, right. So what's the point of do this preliminary inquiry then? What are the police actually trying to figure out during this initial assessment?
The main goal here is to determine whether there is enough there for a full investigation. So they're looking to see if there's a prima facie case, which basically means at first glance.
Right.
Is there enough credible information at this early stage to suggest that a crime within that specific punishment range might have actually happened? And this preliminary inquiry, it actually requires permission from a higher up in the police, someone at least at the rank of deputy superintendent of police.
Okay.
They need to give the go-ahead in writing before the inquiry can happen.
So it gives the police a chance to do a little bit of groundwork, right?
Yeah.
Before they commit all those resources to a full-blown investigation by registering an FIR.
Exactly.
So how is this different from what was happening under the old CRPC?
This is one of the big changes. It's a big departure from how things were done before. Under Section 154 of the CRPC, and the Supreme Court was very clear about this in the Lalita Kumari case, if the information clearly pointed to a cognizable offense, they couldn't do a preliminary inquiry. They had to register the FIR right away. Any preliminary inquiries back then were really limited to situations where it wasn't even clear whether what was being reported was actually a cognizable offense in the first place.
Okay, I see.
But now the BNSS is creating this specific space for a preliminary inquiry, even when it seems like a cognizable offense, within that 3 to 7 year punishment range might have actually happened.
Right.
But they still want to do some more digging around before they commit to a full investigation.
So the BNSS is giving the police a bit more discretion in how they handle these types of reports, especially for those mid-level offenses. Now, let's bring the Imran Pratap case back into the conversation.
Yeah.
What was actually going on in that case? What were the charges?
So this is where the Supreme Court's comments about FIR registration and this whole preliminary inquiry idea, they really come into play. The court was dealing with a case where an FIR had been filed against Imran Pratapgadi,
Okay.
who at the time was a member of the Rajya Sabha, and they were actually overturning that FIR.
Oh, wow.
The case started because of a social media post that he had shared.
Okay.
And this post, it had a video clip in it, and in the background of the video, there was this Urdu poem being recited.
What were the allegations against him, specifically about the poem? What did the complainants say that led to the FIR?
So the person who filed the complaint, they claimed that the poem was designed to incite animosity between different communities and that it offended the religious and social feelings of a specific community.
Okay.
So based on that, the FIR was registered under a whole bunch of different sections of the Harapya Nyaya Sanhita 2023.
Okay.
That's the new penal code that came out alongside the BNSS.
Right.
These sections included Section 196, which is all about promoting enmity between different groups, Section 187.1, which deals with statements or imputations that could harm national integration, Section 299, about deliberate acts intended to outrage religious feelings, Section 302, which covers saying things with the intent to wound religious feelings, and Section 57, which is about abetting the commission of an offense by the public.
Wow, those are some serious charges.
Yeah, really serious stuff.
So what did the Supreme Court have to say about the poem itself? How do they interpret its meaning?
Well, the court, they really looked closely at that Urdu poem, and they also had an English translation to work with.
Yeah.
And what they found, it was quite different from what the complainant and the police had initially said.
Okay.
They specifically said that the poem didn't actually mention any specific religion, community, region, or race. And they also said that it definitely didn't pose any threat to national integration or the sovereignty, unity, or security of India.
So they basically said that those claims of incitement or hurting religious sentiments, they were baseless.
Exactly. There wasn't really any evidence to support those claims. They saw the poem as advocating for fighting against injustice, but in a peaceful, non-violent way.
Interesting.
They even pointed out a line that suggested that injustice shouldn't be met with retaliation, but with love.
Yeah.
And there was this mention of a throne, and they interpreted that as a symbol of the powerful people who are responsible for injustice.
Okay.
It was like a call to sacrifice in the fight against injustice, not an incitement to hatred or violence against any particular group.
So given all that, what was the Supreme Court's reaction to the decision to even register an FIR in the first place?
They weren't happy about it, let me tell you. They called it a very mechanical exercise and a clear abuse of the process of law. Basically, they were saying that just looking at the complaint and the poem in itself, it was obvious that none of those alleged offenses under the BNS were actually there.
That's a pretty strong statement from the highest court in the country. Now, let's loop this back to the idea of a preliminary inquiry, which we were talking about earlier. What did the Supreme Court have to say about that in this specific case, especially with the whole freedom of speech issue?
Right. This is where the judgment gets really important. The court, they really stressed how important the freedom of speech and expression is, which, is a fundamental right for all citizens under Article 19.1 of our Constitution. And they said that when you have accusations of offenses, the ones that could land someone in jail for up to 7 years, and these accusations are mainly based on what someone said or wrote, just like with this poem, then it makes sense to use that preliminary inquiry option,
Right.
which is in Section 173 of the BNSS,
Okay.
before they just jump into registering an FIR.
So they're basically recommending a preliminary inquiry in cases involving speech, but why?
Their main reasoning was to protect people's fundamental rights. They didn't want to see situations where people were being slapped with FIRs just for expressing their opinions, especially when those opinions might not even fall under those restrictions on free speech that are outlined in Article 19.2 of the Constitution.
Right.
By allowing for this preliminary inquiry, the police can take a closer look and really assess the situation before potentially shutting down legitimate forms of free speech.
So they're basically saying that for those speech-related offenses, the ones that fall into that 3 to 7 year punishment category, the police should usually get permission for a preliminary inquiry.
Yep, that's exactly what they're saying. And they even went a step further, saying that the higher-ups in the police, they should normally grant permission for these inquiries in these types of cases. So it's like they're really pushing for this to be the standard procedure, to protect free speech.
Interesting. So it seems like with this preliminary inquiry thing, the BNSS is trying to create a system that's a bit more balanced. It acknowledges that they need to investigate possible offenses, but also that they need to protect fundamental rights like free speech.
Yeah.
Did the Supreme Court offer any guidance on how the police should actually evaluate the impact of spoken or written words in these kinds of cases?
Oh, they did. They pulled from a lot of previous judgments to explain what the standards should be when you're looking at what someone said or wrote. They emphasize that you have to judge these words based on how they'd be understood by a reasonable person, someone who's strong-minded, firm, and courageous,
Okay.
not someone who's easily offended or who sees criticism as a personal attack
Right, right.
or who's, kind of wishy-washy in their thinking.
It's like they're saying they need to be objective and kind of tough-skinned when they're evaluating speech.
Exactly.
Didn't they also talk about mens rea?
They did?
You know, that criminal intent thing?
Briefly, yeah.
What was their take on that?
They talked about it in terms of offenses like promoting enmity between groups.
Okay.
And in this Imran Pratapgadi case, they basically said that when you look at the poem and the circumstances surrounding it, it's pretty much impossible to say that he had any criminal intent.
Right.
And this is a really important point because it means that just saying something that some people might find offensive isn't automatically a crime. There has to be clear intent to actually commit an offense.
So there has to be more to it than just saying something that someone doesn't like.
Exactly.
Now, it sounded like the Supreme Court also had some thoughts about how the Gujarat High Court handled this case.
Oh, they did. They were kind of surprised that the High Court hadn't stepped in to quash the FIR earlier.
Right.
They pointed out that the High Court knew all about the right to free speech, but they still chose to uphold the FIR. They disagreed with the High Court's conclusion that the social media post would certainly create disturbance in social harmony.
Right.
They basically thought the High Court should have used its authority to stop what they saw as a misuse of the legal process.
Wow. Okay, so let's put it all together now. What's the main takeaway for our listeners about registering an FIR under the BNSS, especially considering what the Supreme Court said in the Imran Pratapgadi case?
Okay, so here's the big change. The general rule that FIRs have to be registered for cognizable offenses, that's still there in Section 123 than the BNS 01.
Okay.
But there's this important new element that they've added, and that's the preliminary inquiry in Section 173.0 for those offenses that could carry a sentence of 3 to 7 years in prison.
Okay.
So now the police, with the okay from their superiors, can take a look and see if there's really enough evidence to justify a full-blown investigation before they officially register that FIR.
Right.
And the Imran Pratapgadi case, it really highlights how crucial this preliminary inquiry can be, especially when it comes to cases that involve free speech.
Right.
It's a way to protect people's basic rights and make sure that the law isn't being used unfairly.
So we've covered a lot of ground today.
Yeah.
As we wrap up, what are the key points that our listeners should take away from all of this?
Okay, the big ones are: the FIR is still the most important first step when someone claims that a cognizable offense has been committed. And while the BNSS, just like the CRPC before it, generally requires the police to register an FIR if they're told about such an offense, there's this new exception now.
Right.
The preliminary inquiry under Section 133. And that applies specifically to offenses that could lead to a prison sentence of somewhere between 3 and 7 years. And that Supreme Court judgment in the Imran Pratapgadi case, that really hammers home how important this preliminary inquiry is, especially in cases that involve freedom of speech. It helps to balance the need to investigate potential crimes with the need to protect individual freedoms.
And for you, listening out there, why is all of this so important? How does it affect you and your rights?
Well, these changes in the law, they really have a direct impact on how the police are going to handle complaints,
Right.
especially those that involve tricky areas like freedom of expression. Knowing about this preliminary inquiry process is really empowering because it means you understand that not every single accusation of a cognizable offense is going to lead to an immediate FIR. There might be an initial assessment first, which can make a huge difference. Whether you're the one reporting an incident or the one being accused of something, it just creates a more nuanced approach that takes into account all the complexities, especially in situations that deal with free speech and expression.
That's a really important point.
Mm-hmm.
So to finish off this deep dive, let's leave our listeners with something to think about.
Okay, yeah.
What's a thought-provoking question that they can ponder?
Here's one. With this emphasis on preliminary inquiries in the BNSS, how well will it actually balance the need to take quick and effective action in legitimate criminal cases with the need to protect individual rights, especially that fundamental right to free speech, in our constantly changing social and digital world? think about the kinds of situations where this new provision could have the biggest impact, and maybe even do some more digging into the Harathanagarika Sanhita yourself.
Mm-hmm.
Get a better grasp of how all this is changing the legal landscape.
It's a lot to think about.
Yeah.
Thanks.
Thank you.